Hello and welcome to a new episode of White Collar Crime Legal Series. This is Dr. Arjun Chaudhary, advocate. It's 7 a.m. You hear a loud knock. The Enforcement Directorate is at your door. No warning, no intimation, no prior complaint, and they are here to search your premises and seize your assets. So, what exactly happens during an ED raid? Let me break it down step by step for you. ED doesn't conduct raids randomly. A raid, officially called a search and seizure operation, is triggered by credible information that someone is involved in money laundering or is in possession of proceeds of crime. So the Enforcement Directorate investigates based on ECIR. We have already discussed about it, which is equivalent to an FIR registered by the police. Information from other agencies like the CBI, like the DRI, like the income tax, or even by the SFIO, or on the basis of tip-offs, suspicious transactions, or any link to scheduled offence under the PMLA. So under section 17 of the PMLA, the ED is empowered to enter and search premises, break open locks, seize documents, digital devices, money or property, record statements on the spot. And yes, they don't need a magistrate's warrant to conduct the search operation. They only require a reason to believe that evidence may be hidden or tampered with by you. So the raid usually begins early in the morning. Without prior notice, a team of ED officers arrives at your premises, often accompanied by the local police for support, as well as independent witnesses who are usually the local witnesses. In the language of ED, the independent witnesses are known as panchas. So officers, they show their authorization to search, not a court warrant, only an authorization is issued by the superior officials. And you are legally obligated to cooperate with the officers during the search process. So once the ED officers are inside your house, all individuals present in the house are asked to stay in specific rooms. Officers conduct a thorough room-by-room search. All lockers, safe, almirahs, digital devices are inspected. Even digital data like emails, phone contents, cloud storage may be cloned and seized if the ED officers believe that they are relevant evidence. They maintain a panchnama, which we call in our language seizure list, that is an official document detailing what is found and seized, signed by the witnesses and the persons being raided. Even the personal mobile phones and laptops may be taken if suspected to contain relevant evidence. So if incriminating evidence or proceeds of crime are found, they are sealed and seized. ED officers also record statements under section 50 of the PMLA. These are not like the normal police statements recorded under section 161 of the CRPC. These statements recorded by the ED officers under section 50 are admissible in a court of law, and refusal to answer or refusal to give statement to the ED officers may amount to an offence. So if the person resists or obstructs the search, the ED may take legal action under section 63 of the PMLA Act. Now what happens after the raid? After the raid, a copy of the panchnama, that is the seizure list, is given to the person raided. Seized items are listed and acknowledged. ED may call the individual for further questioning if there is any requirement. The search report is submitted to the adjudicating authority within a period of 30 days. And in many cases, the next step may be provisional attachment of the property and eventually arrest. So ED raids are serious. They disrupt lives, they freeze assets, and can lead to long legal battles. But knowing the process, your rights, and the law helps protect you if you are ever in the crosshairs. So if you are a business owner, a professional, or even an investor, stay compliant, because under PMLA, ignorance is not a defense. That's all for today. Thank you.